Lawyers Solictors. What is the strangest or oddest law that's won a case for you? My brother is a lawyer. He got a DUI charge dropped for a client. Guy gets pulled over. Cop asks him to step out to perform the sobriety test after he admits to having consumed some amount of alcohol. He complies, but after stepping out of his car asks the officer if it's okay for him to reposition his vehicle to move it further away from the road because he feels uncomfortable being that close. The cop obliges. Apparently the charge got dropped because the officer willingly let an intoxicated individual operate a motor vehicle. Effing genius. I have one where we won, but didn't quite go as planned. I had a client a while ago who was incarcerated at a state prison farm. Inmates had to spend 40-60 hours a week preparing slop for the hogs from expired restaurant food and cleaning the hog barns. He reeked every time I met with him. Even after showering he said it was miserable. Well, he found out that some Muslim inmates, who couldn't work with pigs, were offered to be able to work at the police horse stable instead. 5 minutes down the road, he wanted to sue, saying that stable work is much less revolting than hog work, and that this amounted to unequal punishment on the basis of religion. I thought he had a point. Well, the case didn't get thrown out and actually got some traction. But then the prison changed their policies in response. Inmates who couldn't work around pigs, or didn't want to, would instead be transported to a factory chicken barn the next county over for work each day. He asked that I drop the lawsuit and the Muslim inmates were not happy with him. In 2016, prison inmate John Modi was charged with escaping from the prison in which he was incarcerated, which is a crime in Ohio. The prosecution, however, failed to establish that the Hocking Correctional Facility, and therefore the crime, was located within the court's jurisdiction of Hocking County, as all witnesses potentially able to offer testimony on the prison's location had gone home for the day, and, incredibly, no one remaining could provide references allowing the court to take judicial notice of the prison's location. The charges against Modi were dismissed, and he was allowed to return to prison to serve his sentence, but at least without additional charges concerning his alleged escape. Have a friend who's a lawyer. Apparently a city had made a new law that if you don't pick up your dog's poop, you can be made to do so with bare hands after hearing how effective that law was in some country in Europe. But the law got thrown out for being a cruel or unusual punishment, or something like that. So he recommended an alternative means of getting it into the law: make it be the defense to the crime instead of the punishment, and increase the punishment to incentivize people to do it. The draft of it he sent me was something like, a person who fails to immediately remove the waste of their pet, or any animal under their control, from public lands, violates the animal waste ordinance and shall be sentenced to a minimum of 3 days in jail and no more than 30, in addition to a fine of up to $200. It is an affirmative defense to this offense if, upon being confronted by an officer, the offender immediately A, admits responsibility for the offense, and B, at the direction of the officer, picks up the pet waste using only the offender's bare hands, until it is disposed in a legal receptacle. No penalty shall be imposed if the offense is caught after the fact, and the offender's pet's waste has already dried, washed away, or been disposed of, or if the offender expresses willingness to employ the affirmative defense above but has visible cuts, scratches, or other abrasions on the hand, or any illness, or is pregnant. The officer may, at his or her discretion, ask the offender to pick up a different animal's waste with bare hands at a later time as appropriate. This shall satisfy the affirmative defense above. The waste may come from a police dog or a police horse. Ianal. But I won my case by exploiting a legal technicality in my jurisdiction. My case needed to be tried at a certain court, but they tried me in another court, and by trying me in the wrong court, basically broke the law. I made them aware of this, and had my case dismissed. Had a guy in USAF basic training that should have been a lawyer. When pulling dorm guard duty we were supposed to ask anyone requesting entry to show their military ID through the window in the door, and compare the name shown to an approved entry list. Failure to confirm ID before allowing entry was a security infraction. So this one dude is dorm guard when a TI, training instructor, is going around from dorm to dorm to make sure the airmen on duty are following procedures. The TI knocks on the door and demands entry. For whatever reason, the airman lets the TI in without asking to see ID. The TI blows a gasket and starts screaming at the airman how much trouble he's going to be in. When the TI reports what happened, he demands the airman hand over a form 341, which is used to document rules infractions. Airman: sir, I'll give you a 341, but I think you should know this door is broken. TIWFT are you talking about, airman? Airman: sir, we found out if you kick the door on the bottom left corner it opens whether it's locked or not. TI: show me what you're talking about. The two step out into the hallway and the airman shows the TI where to kick the door. Airman: sir, let me step back inside and lock the door so you can try it yourself. The airman steps back inside the door, then locks it. The TI tries kicking the door, but it remains locked. TI: airman, I thought you said this door is broken. Airman: huh, it worked the last time I tried it. TI: well, it looks like it's working fine now. Open up and give me a 341. Airman: sir, if you are requesting entry to the dorm I'll have to see your ID first. Had a case where my defendant opponent filed an appeal from an administrative agency to the local circuit court. The requirements for filing the appeal are very strict, and the filing must include an appeal bond, executed by the individual defendant, or a corporate officer. When my opponent's assistant electronically filed the appeal, she attached a PDF of the bond without the corporate signature. There's no question in my mind they had the bond with the requisite signature, and simply attached the wrong version of the document to the filing. Wish I could say there was a huge court fight over this, and I got to slam my opponent, but that's not how this works among professionals. I waited until after the time to correct this error had passed. I then politely called my opponent, told him that I was holding the I win button, and that I'd be filing a motion to that effect in a week. My opponent came to me with very favorable settlement terms within days. To this day, I don't know for sure if my opponent ever disclosed his mistake to his client, but I doubt it. The Canadian Interest Act specifies that all interest must be specified in a per annum percentage. If it is not, it's struck down to 5% simple interest per year. The number of lenders and creditors who try to pull off a 4% monthly compound interest, but aren't familiar with that provision of federal law. Had a family member get a DUI. He was sleeping in a parked car on the shoulder of a rural road across from a restaurant. Witnesses called in that he was drunk and had pulled over, stumbled out of his car, urinated on the roadway and then fell asleep in the car. When police arrive, the body camera shows him absolutely hammered, stumbling. The officer asked him when he started drinking and he slurs out that he had started drinking at 9 AM. It was about 5 PM. He takes it to jury trial. His version of events in court was that he was driving sober, had pulled over, and then began drinking only once he was parked on the side of the road and therefore never actually operated the vehicle while intoxicated. Prosecution played the body camera of him hammered and stating he had been drinking since 9 AM. The prosecution focused the jury's attention that the video statement and his in-court statements obvious both weren't true. His attorney stated that since he clearly was so intoxicated in the body cam video that it was unreasonable to believe that he was telling the truth when he said in the video he had been drinking since 9 AM and that his in-court statement was more credible. He essentially argued that you couldn't convict him of being too drunk to drive based on the evidence against him because he was too drunk to make the evidence against him credible when he made the statement against himself, and they fine acquitted. I won a case where the defendant, New York City, tried to exploit a really stupid law, which I was able to use to win the case. This was a slip and fall case where my client had tripped on a piece of broken sidewalk outside of the Natural History Museum and shattered her arm and wrist. The law is that a property owner is responsible for the sidewalk directly outside of their property. The theory being even if they can't fix it, they have a duty to warn people about hazards and mark the area off. The museum was owned by the city. There's another concept called sovereign immunity, which is that governments can't be sued without their consent. So the city had passed a very stupid law that they would be exempted from the rule that they can be sued for sidewalk injuries unless you can show they were on notice of hazard. Meaning, you would have to show that you informed the Secretary of State, Governor, Mayor, etc. of the exact specific crack in the sidewalk before the injury occurs, and you had to do so in writing with ample time for the city to remedy it, 180 days in advance. Under normal circumstances, This is impossible because no one anticipates tripping on the sidewalk 180 days in advance with the foresight to write a letter to the mayor about that specific crack. Luckily, someone did have that foresight, and there was a non-profit called Big Apple Maps which would go around the city and with maps of government property and record with insane specificity each and every crack in the sidewalk, pothole, protrusion, and other hazard, and then publish these maps while serving copies on the government, with the express purpose of combating sovereign immunity defenses in slip and fall cases against the government. I got a hold of one of these maps and visited the site, and I was able to take pictures of the section of the sidewalk where my client fell, and you could see newly placed concrete over the area in the exact position indicated on the map, showing where the sidewalk had been repaired after my client slipped. Basically, the government's attorney brought up the sovereign immunity defense and outlined all of the stupid steps I would have needed to go through to overcome their motion to dismiss. My response was, "Oh, you mean this?" and gave them the map. Immediate settlement. Contrary to popular perception, the legal system does not involve a hunt for some arcane law that lets you win with this one simple trick. The closest I have ever come to that, and it was a complete aberration, was a complex dispute over the validity of mortgage note with a bank. One of the issues was whether there was sufficient consideration, something of value, exchanged for the note. I dug up an old case that said if the mortgage contract was sealed, consideration was presumed, and sure-ish, the contract had seal written after each of the signatures, so that resolved that particular issue. But then there were a whole bunch of other allegations of fraud, self-dealing to sort out. 90% of legal cases involve credibility disputes between witnesses about what happened, not finding some magical Harry Potter type Latin spell to utter in court. I had one where a client was contesting a will. Halfway through the case, the other side argued that my client was set to inherit less without the will, if we won, than she would with it, if we lost, and argued she lacked standing to attack the will. The decedent had a very old will that benefited our client's deceased mother, but that will had been revoked. We found a very old doctrine in a footnote to something else entirely and argued to the judge that the law assumes you'd rather die with an old, revoked will than with none at all. Therefore, we argued he should look back to the prior will, since our client would inherit her mother's bequest under the prior will. He held our client had standing to bring the will contest. We ended up settling the case shortly thereafter.